Hi there, students. I hope you're all hale and hearty. Moving on with the next part of the lecture with respect to forest conservation. Well, in the last class, in the last lecture to be very specific, we started discussing Forest Act of 1927, a legislation which was enacted way during the colonial era with an objective to ensure, I would rather say, regulate cutting of trees and earn revenue from it. In fact, this particular legislation of 1927 denied common ownership and occupancy rights to the forest dwellers, the then tribals who used to dwell in those forests. Forest, is, forest, especially at that point of time, was also declared as a government property under this law. The Act of 1927 also established Forest Settlement Officer, and it was the Forest Settlement Officer who would have the full rights to determine the extent of their rights of the dwellers. And these rights were basically like rights to graze, water resources, rights to cultivate, shifting cultivation, forest produce, etc. etc. And basically, this Forest Settlement Officer under the Forest Act of 1927, they had to notify, hear, and decide the claims. Now, the thing is that with respect to this 1927 law, it was mainly enacted with an aim to supply raw materials for the forest based industries. In fact, for that, I insist you refer to an article written by I mean I don't know, it's something which for that you need access to library. There's a book, not an article. There's a book by Chhatrapati Singh. He was a very famous environmental law scholar. uh, he's not there anymore, but his work been very extensively, wide enough to cover several issues relating to environmental law of our country. So Chhatrapati Singh, he wrote a book on common property and common poverty, and it was way back in 1986. It was an Oxford University Press publication. So if you get hold of this book, Common Property and Common Poverty by Chhatrapati Singh, there he has very rightly pointed it out that this particular legislation of 1927, it was moreover to deprive the nomads and the tribal people of their age-old rights and privileges to use the forests and to have access to those forest produce. So basically, this particular legislation of 1927 was enacted in order to supply raw materials to the industries, and forests were basically accepted as a significant factor in order to attain that revenue which they were targeting. And when I'm saying they, I mean the Britishers. Now, it is also very necessary to point out that this revenue oriented attitude towards the forest, in fact, continued after independence. So it is something which is quite, it's a fair criticism I'm making, that this act of 1927 failed miserably to conserve, protect, preserve the forests from these exploitations by the state entities, which are, or even private entities, which are highly unplanned and at many occasions very much unscientific in nature. There are some case laws where the honorable, judges and esteemed lawyers forward several arguments with respect to forest conservation. There's one case of Ishwar Chandra Gupta versus State of Uttar Pradesh. It's an Allahabad High Court case where it was made very clear that the scheduled tribes and other traditional forest dwellers, if you remember, I have mentioned that previously, that in 2006, for the very first time, the rights of the forest dwellers, of course, categorized into segments, the scheduled tribe forest dwellers and other traditional forest dwellers were recognized. And this particular rights were recognized with the enactment of this particular law, titled Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. So the Allahabad High Court referred to this particular enactment along with the Forest Act of 1927, and it made it very clear that these two legislations run out very derogatory to each other. And these two acts run in different field, and there is no inconsistency between the provisions of these acts. And in this particular case, the petitioner was running a shop in a forest area since 1928, but they could not prove that they themselves were forest dwellers or so-called traditional or even the scheduled tribe forest dweller. Therefore, they were denied the basic right to continue their possession over the forest land, which were, of course, with respect to that activity which was non-forest in nature. In fact, if you refer to the penalty of that particular legislation, you will find that the penalty provisions in the Act was it prescribed a maximum punishment of 6 months imprisonment with a fine which may extend to 500 rupees. And if you refer to section 63 of the legislation, you will find the imprisonment which it has been provided for was extended to 2 years, could extend to 2 years, or a fine which in both cases were kind of defacing, or if you're defacing or putting any marks on the trees, timbers, or even altering the boundary marks of any such forest and forest land, then section 263 will be invoked. This 1927 legislation also encountered several amendments, like the Amendment Act of 1982 gave greater power to the domiciled people of the forests. And this was previous to 1976 because you already know that the 42nd Constitutional Amendment Act of 1976 has given the power uh, to legislate on forests to the union government, but prior to that it was just the states who had the power to legislate on forests. So, similarly, this amendment has laid down that it is the duty of the state to improve and protect the environment, which also includes forests and wildlife. This is something which was clearly held with the inclusion of Article 48A of the Constitution. In addition to that, there are a series of cases. The name of T.N. Godavarman versus T.N. Godavarman Thirumal Par versus Union of India. Now, this case, which I'm referring, is from the year 2006, Volume 5, Supreme Court Cases 28, where the petitioner challenged that the allotment of a particular land, which was of around 15 hectares, which was given to a particular entity called Maruti Coal and Power Limited on lease for establishing a coal washery. It was claimed that this particular land, which was leased out as a was a forest land, and it could not be used for any non-forest purpose. And coal washery was basically a non-forest purpose. So the Honorable Court reiterated that the definition which was given to this so-called the term forest, it should be understood according to its dictionary meaning. And when it referred to the dictionary meaning of the forest, it covers all statutorily recognized forests, whether it is designated as so-called reserve forest, protected forest, the categories that I have discussed in the previous online lecture. So they must be understood in the dictionary meaning. So, moreover, it also includes any area. In fact, they have taken a very practical approach that any area which is measuring 10 hectares or more and having an average number of 200 trees per hectare. So, any area which is measuring 10 hectares or more or having an average number of 200 trees per hectare ought to be treated as forests. And moreover, it was also included that any area which is recorded as forests in the so-called government records, irrespective of their ownership. So this matter was related to, disputed land, and hence the Honorable Court referred the matter to an executive committee, CEC, which gave certain reports, I believe three reports to in three different occasions, and it declared that the land in this matter was a non-forest land. So it was declared that the petitioner did not come to the court with clean hands, but there were certain other motives behind it, and the court dismissed the petition with the costs, and also at the same point of time warned the petitioner not to recuperate the language of the cleanings. So this is with respect to the Godavarman case. In fact, with respect to this particular judgment, certain principles were also laid down by the Honorable Supreme Court, and that is the reason because of which the Godavarman case is very significant with respect to forest conservation, protection, and preservation. The following principles, which I pretty much I'm referring here, just keep it in mind because they were adopted out of this particular judgment. First and foremost is that the Honorable Court clearly highlighted that the principal objective or principal aim of a forest policy is to ensure environmental stability, to maintain ecological balance, and this includes atmospheric equilibrium also. So any derivation of this direct economic benefit must be subordinated to this particular principal objective. So the forest policy, they have a statutory flavor, and any non-fulfillment of this particular principle would violate Article 14 and also Article 21 of the Constitution. First. Second, the concept of CAMPA, so-called the Compensatory Afforestation Fund Management and Planning Authority, was also established. Compensatory Afforestation Fund Management and Planning Authority was also created by the Ministry of Environment and Forest. Of course, now it's Ministry of Environment, Forest and Climate Change, and according to which the CEC is very much essential, and it shall allocate money to the states for site specific schemes, and these schemes were of course out of will be out of compensatory afforestation fund, and this fund will be created having regard to the principle of sustainable justice, so called intergenerational justice. In fact, thereafter, the Honorable Parliament, Union Parliament, has also adopted and passed this Compensatory Afforestation Fund Act in the year 2016. Not that far in the chapter of our legislative history. Just in 2016, the Parliament passed this Compensatory Afforestation Fund Act, according to which it is necessary that for any economic development or welfare related project where you want to use the forest for any non-forest produce, then before that you have to take prior permission, which will be granted by the CEC. The CEC, that executive committee which was established by Godavarman in that particular case, which I referred a while back. And there should be certain schemes, it can be short-term scheme or long-term schemes for regeneration of forests. And this is something the constitution of Campa should be in accordance with section 3 subsection 3 of Environment Protection Act 1986, which in fact gives the central government the power to do so. Whatever money is received in this, the next principle is that whatever money is received towards this compensatory afforestation or any additional afforestation or penal compensatory afforestation or even the net present value of any forest land, catchment area, treatment plant, all of them will be deposited to this compensatory afforestation fund. So if you're getting the money out of compensation, penal compensation or net present value of that forest land or any catchment area or treatment plant fund, so all of them will be taken to the CAF, so called the compensatory afforestation fund. And this fund received from the user agencies, they shall be used exclusively for undertaking conservation activities of the forest, nothing for something else. Okay. Another principle is that any kind of artificial regeneration activity should be encouraged, should be started at the earliest, and you should involve the local communities so that the local species and endangered species can be planted, because they are also having the traditional knowledge, indigenous knowledge about those species. So local and indigenous species must be used for plantation in situ, not ex situ at all. Another principle which was adopted by Honorable Supreme Court was that there should be an independent system of MRV, right? Monitoring, reporting, evaluation. So monitoring and evaluation should be evolved over the period of time. And finally, the forest management planning should involve a blend of not just ecological factor but also socio-economic system in which both the ecological and social sides of the planning will be pretty much portrayed. So this is something which was clearly held in the Godavarman versus Union of India 2006 case, and that is why it is very important. And all these principles are very significant because that gave birth to this 2016 Compensatory Afforestation Fund Act. However, after independence, this Forest Conservation Act came into existence. Although this act was not with respect to the recognition of the rights of the forest dwellers, but the central government, which got its power from the amendment, the 42nd Amendment, and with the particular power, the Union government passed this Forest Conservation Act in 1980. Now, this is a landmark legislation in the history of the protection of forest because it kind of removed several difficulties which the Forest Act of 1927 was portraying. This basically is a very small legislation. It has only 5 sections, and that has been proved very effective and successful over the period of time. Why is it so? Because the first and foremost objective of this legislation was to provide for conservation of forests for any matters connected thereto, therewith, and ancillary or even incidental thereto. The conservation of forest is significant because deforestation, as you know, causes ecological balance that leads to further environmental degradation and deterioration, and that's why this act was passed to conserve. So now the approach kind of changed. Previously, the approach of the forest law was basically for revenue generation, more of an economic value, but now they have kind of switched to the conservation side or the conservation angle of the forests. In fact, this particular legislation is important because this kind of also impose certain restrictions on de-reserving a reserve forest. If you remember in the previous lecture, I mentioned about certain categories of forests, and reserve category, which is so all known as the reserve forest, cannot be used for there are several any kind of economic activity or non-forest produce related activities are strictly prohibited. But those reserve forest can also be de-reserved, a part of it, a portion of it, or in entirety, it can also be de-reserved. But for that, it's not just you can go ahead and de-reserve. The state cannot just go ahead and do that. There is a procedure which has been established by this particular legislation, and there for that you should refer to section 2 of Forest Conservation Act, because it clearly says that no state government or any authority which make except with the prior approval of the central government, which is very much necessary in order to de-reserve a reserve forest. And I have to cite that that particular reserve forest, or as enshrined under the 1927 Act, it will cease to be reserved, or a portion of that particular forest, or even a particular portion of that forest land can be assigned to a particular entity on lease. All these things has to be done, but it should be done after having prior permission, or so-called not just consultation, but it's the central government whose prior approval is mandatory and required. And this was also reiterated in several judgments, including the Godavarman case. When this case was from 1997, you can refer to 1997 Volume 2 Supreme Court Cases 267. This is also known as the Godavarman third case, where the court clearly held that the word forest must be understood according to dictionary meaning and according to the section 2 of Forest Conservation Act. That description is covered. So forest land, which not only include forest as understood in dictionary stem, but also include the area which in fact is recorded as forest in the government records. And when you talk about non-forest produce has also been defined as breaking up into cleaning of any forest land or any portion of that forest land for, say, cultivation of tea, coffee, spice, palms, rubbers, oil bearings, plants, horticulture crops, or any other purpose other than reforestation. In fact, Section 2 further clarifies that this non forest produce, it should not include any work which is related to or ancillary to conservation, development, and management of forest and wildlife. So, establishment of checkpoints, wireless communications, construction of fencing, bridging, cultural, dams, water holes, and all, they are not so-called non-forest purposes, because these are used for protection, preservation, and conservation. So, if say for example government has built a wireless communication, or if it is constructing a fence across a reserve forest, although it might appear to you as a non-forest purpose, but it is not, because you're using the fence or wireless communication for protecting the wildlife, for conserving the wildlife, or so-called the plants inside it, or even other forest producers. So this is something which was also clearly held. Okay. Few other cases which are also relevant with respect to the forest related matters. That is the Om Prakash Chaudhary versus State of Rajasthan's case, where the court clearly held that construction of so-called interpretation center in a forest area is not covered under the non-forest produce. So, which was in fact here in this particular case, National Wildlife Action Plan of 1982 was referred. It was referred by the Honorable Court. So, according to which it made a provision for establishment of model interpretation centers at wildlife units for educating the visitors, creating awareness about wildlife. So, this was a conservation of wildlife activity, and this is something where the court held that there is no need to seek any prior approval of the central government to go ahead with non-forest kind of a activity. Another case was Vilas Shankar Donode versus State of Maharashtra, where the Honorable Bombay High Court clearly held that the use of forest land for construction of road was non-forest purpose, because construction was illegal in this case, and the court in fact ordered the closure of the road, and it also ordered that this particular site should be reforested. Further, the court in fact declared that the cost of which is incurred for reforestation, for reviving the damaged which was caused by the entity, all should be included. It should be recovered from the MLA of the ruling party who exercised his influence in the forest department for that road construction. So MLA of a ruling party was like pecuniary held liable for this, and he was asked to pay for the damages. There are a few more cases also which are relevant in this context. Of course, two cases that I would like to mention over here. Uh, One case is the B.V. Sri Kumar versus the Chief Conservator of Forests. This is a case from 2017, very latest case, where it was held by the Honorable Karnataka High Court that Section 2, Clause 3 of the Forest Conservation Act restrict the rights of the state government to transfer or create any right over a particular forest land. So this is a prohibition which has been granted. It is a prohibition on the grant of any right under Section 20 of Wildlife Protection Act also. So, and also Section 35 of the same Wildlife Protection Act 1972. So, as such, no one can have a right even to seek easementary right in a forest land, invoking Section 13 of Easement Act. So, Easement Act and Wildlife Protection Act was also referred along with the Forest Conservation Act in the case of B.V. Sri Kumar versus Chief Conservator of Forest. 2 years prior to that, this is a 2017 case, but 2 years prior to that, the Ministry of Environment, Forest and Climate Change also came up with a circular on June 24th, 2015, which in fact allowed the use of forest for non-forest purposes and it was specifically for laying down oil pipelines and other petroleum mining leases in the forest area. And in such cases, the prior approval of the central government is not a sine qua non. It was rather not required to, in fact, they will also not be required to pay the net present value. So this is something which the central government adopted. I insist you please refer to the circular from 24th of June 2015 by the Ministry on of Climate Change, of Environment, Forest and Climate Change. In fact, it has also been recognized that any development of these tribal villages or even those forest fringes can be ensured by providing some basic and essential development facilities, and there is a sense of security which is required in these sensitive areas, and it should not be done also at the same point of time without it should not be done by compromising the environmental considerations. So there should be a balance which needs to be made between the economic developmental considerations and ecological considerations. So this is what it was held, and there is a guideline also which came from the ministry in 2003, which was especially with respect to electricity cables and electric wires in individual households and drinking water supply. So the ministry has also from time to time passed several such circulars for conserving, protecting the forests. In fact, there is also provision for constitution of advisory committee. If you refer to the Forest Conservation Act for the same, in fact, there you will find the central government can also constitute an advisory committee, and this advisory committee or steering committee enables the central government to decide whether the requisition by the state government to reserve a reserve forest should be considered or not. So, the grant of approval by the central government is also based on the recommendation given by the advisory committee to the central government, and thereafter, central government kind of moves over it and decides whether to give approval to the state government to de-reserve a particular reserve forest or a particular area in a reserve forest. Finally, in today's lecture, I would also like to highlight the Silent Valley case. The Silent Valley case is very important because, in this case, the area of the Western Ghats, you remember the documentary that I have screened in the class, the Western Ghats of India and in the state of Kerala, which is also known as the B.A.L.B Ghat. It contains India's largest tropical evergreen forest, right? And it's very massive, and a lot of endangered species live in there. So there were certain, hydrological balance which was pretty much under threat because of certain economic activity. Now the state, because the state of Kerala, which started constructing this, hydroelectric project in the Silent Valley area, the experts, scientific experts, you remember Madhav Gadgil, they in fact realized that there is a dire need to reconsider this. In fact, experts which were attached to the Department of Science and Technology of the government warned against this proposed plan. They in fact warned that this deforestation would interfere with the balance of the nature. And the state of Kerala in fact pleaded the necessity of more and cheap electricity for the poor people. So what happened is that there are two instances in this case. On one side, the need of electricity for poor people, and that too in cheap, and on the other side, you have the ecological imbalance. So the Kerala High Court accepted the stand of the state government and gave a judgment against the environmentalists and conservationists. In fact, it did not think that it was proper to evaluate the scientific study of the project, right? So, if I may, I would like to quote the Honorable Court in this particular case. Pretty much say that, and I quote: "It is not for us to evaluate these scientific, technical, technological, or even ecological considerations again as against the evaluation which has already been done by the government. It is enough to state that we are satisfied that the relevant matter has received attention before the government decided to launch the project, and we are not to substitute our opinion and notion on these matters for those of the government. So we find no reason to interfere. We dismiss this application with order to costs." So this particular judgment, in fact, portrays some casual attitude, and some scholars also cited as callous attitude, which was adopted by the Honorable Kerala High Court, which didn't think that it was necessary. This judgment was further opposed by several environmentologists, NGOs, and scientists. In fact, there were so many such instances where the honorable courts in fact goes ahead and gives such judgments which goes against the interest, and this was in fact discontinued. In fact, there was another instance which you guys can also refer, that was in Bastar. It was with respect to that Bodh hydro electric project. The same kind of instance, in this case it was state of Maharashtra, and state government was also given was also under the allegation of not giving enough thought and weightage to the issues like economy, culture, and ecology, and all these things together. So this balance was not taken into consideration. So there are several such instances where even the judicial interpretation didn't attain the goal of the forest conservation laws and the jurisprudence that we have in our country. So please think over it and read the materials which are available with you. I'll also send across, and I'll share those materials on easyclass.com. Okay, I have also shared some list of case laws from pollution related matters. Please, those who have already signed up for the Easy Class website, it's good. Please refer to that. Those who haven't, I insist you please take the code. It's there in your email and access code, and do refer to those case laws which I have already shared in there. So this is all for today's lecture. Until then, we'll meet and we'll discuss about some other facets of environmental law in the days to come. And we'll start with Forest Rights Act also. So until then, take care.